Okay, you may be seated. All right, continuing with the cases as listed on the docket, Cohen versus Walt Disney World.
May it please the Court, Barry Novak, appearing on behalf of Appellant Marvin Cohen, along with Steve Mason. I would like to reserve 5 minutes for rebuttal.
Okay, let me get this started. Okay, you're ready.
I'm going to confine my argument this morning to the issue of the agreement of the parties and the jury instruction and defer to the briefs with respect to the remaining issues. This case is about a 68-year-old gentleman who was negligently misled by the defendant to go on a Tower of Terror thrill ride and suffer a stroke. Mr. Cohen and his grandchildren went to the Disney resort.
What about the warning sign that Mr. Cohen observed?
I will get to that, Your Honor. The warning sign basically said, this is a mysterious drop into the twilight zone. He took it euphemistically to mean that basically this is going to be some type of...
It says the Twilight Zone Tower of Terror features a high-speed drop into the mysterious realm of the Twilight Zone. For your safety and comfort, you should be in good health and free from heart, back, or neck problems, motion sickness, or other conditions that could be aggravated by this adventure. And then it gives the height requirements and that sort of thing. And I'm trying to understand why that isn't an adequate warning that Mr. Cohen should have heeded before he got on the ride in the first place.
Well, because when you take the sign itself and the context in which it was given, and you enter the ride and you see the Twilight Zone theme, and then when the doors open and he sees seats and a bar, and he asks the attendant, what is this all about? And he says, we have an unusual elevator. And he says, what's so unusual about it? And he says, mysteriously, you'll see. There was an exit door where he could have left. He is ride-averse. He is not a gentleman who goes on thrill rides, especially with young grandchildren.
No, but my question, my concern is that and it says warning in capital letters, and there's an exclamation mark afterwards. And it seems to me that this would put any reasonable person on notice that, that this is the ride that you don't go on if you have any pre-existing conditions or any health concerns at all, and it's a high-speed drop into the mysterious realm of the Twilight Zone. I mean, it seems to me like that is a warning people, what this ride is, and you don't go on this ride if you've got any health concerns at all.
Had they said, as they did in the brochure, that this is a 13-story drop faster than gravity, that would have been an adequate description that would have put them on notice. But when you have a euphemistic sign that is unclear, especially the way it is themed in terms of the Twilight Zone, he thought it was some type of haunted house or some type of place where you're going to be scared, you're going to be some illusion, but not a thrill ride. Every other attraction that involves high speed is very specific at Disney. It says specifically this is a high-speed roller coaster.
Well, the standard is what a reasonably prudent person would know or should know. And isn't that basically what we have to look at? Is this the type of warning that would put a reasonable person on notice that, you got to be careful and that this is a high-speed drop, and you don't go on the ride if you've got any health concerns at all?
Well, number one, he had no specific health concerns, but number two, it's not specifically just the warning. Disney's operational manual states if somebody asks about it, don't underplay it, don't overplay it, play it straight, tell them what it is. He obviously had some concerns because he wasn't sure what this was all about. Therefore, he asked. That person, just before the elevator, was the last person that could have said to him, sir, this is a high-speed thrill ride, and he would have said, no, thank you. He obviously had some concerns. And Disney obviously felt that other people may have concerns. That's why in their manual they said when people ask, tell them about the ride. So not everybody is going to be 100% able to look through the language, look through the signage, look through the decorations on there and figure it out.
I don't know that it needs to be a sign that puts everybody 100% on. I think it has to be a reasonably prudent person, and you know, to put the average person on notice. I mean, there is certainly going to be some people that just aren't going to heed any warning or understand the warning. But is this the warning that would have been given by a reasonably prudent person to other individuals to put them on notice? It seems to me like it probably is.
Well, I believe the evidence presented was that it was not, that there was some ambiguity in terms of the warning.
Okay, get to the jury instructions.
Okay, so basically, we worked this case up. There were 4 theories of liability you had: premises liability involving dangerous condition, negligence in design, operation, and warning, strict products liability, and a common carrier theory. The latter 2 were thrown out by summary judgment motions. We had a choice as to how we were going to work this case up: premises liability, negligence, or both. We chose negligence. By the time we got closer to trial, there was a pretrial order that both sides had to agree to, and we had a joint pretrial statement in which there was an agreement by both sides that the following issue of fact remained to be tried by the jury. Number 1, was there any negligence on the part of defendant Walt Disney World Co. in its operation and/or warning of the Tower of Terror, which was a legal cause of the injury allegedly sustained by plaintiff Marvin Cohn? The day of trial, after we chose...
You're saying that is a stipulation concerning active negligence as opposed to premises liability.
Correct.
Where there's a dangerous condition on the
active negligence out of the Beatty case, out of the Marriott case, out of the Etheridge case.
Right.
So we chose active negligence rather than dangerous condition premises liability because of the proof that was developed. That's how our experts were worked up. That's how the trial preparation was worked up. The day of trial, we get a unilateral amendment of the stipulation, and all of a sudden it's dangerous condition. No motion was made, no order was made. We complained to the court about this. We said, Judge, we had agreed.
Well, that was one of your theories, wasn't it?
I'm sorry?
Wasn't that one of your theories? You're just saying it wasn't the only, that you should have had an instruction on active negligence as well, right?
Yes. We had a choice, and when the court gave premises liability, we said to the court, fine, give premises, but also give active negligence. The defense argument is, well, we had to change our stipulation because the Supreme Court came out with jury instructions on premises liability. Well, all the Supreme Court did was codify or make forms of jury instruction. It didn't change the law. The law was always there. So we never had an opportunity for the jury to consider whether or not there was negligence on the part of Disney in its operation and or warning. We didn't have any negligence in terms of design. That was not part of the stipulation. It was solely operation and or warning. The jury never had an opportunity to consider that because the first question on the special verdict form was there a dangerous condition? First question out of the box from the jury was, can we consider the signage? No, just consider the ride. No dangerous condition. So they never got to the issue of whether or not the warnings were adequate. And that was a jury question. So we feel, both based upon the fact that there was a stipulation, that we were prejudiced, they changed the game on the day of trial after months, if not years, of preparation in this case, and then when we asked the court to give us a negligence instruction, as well as a premises liability instruction that they wanted, although we don't think they should dictate how the case should be presented to the jury, the judge refused, says, no, this is a premises case, you have to give premises liability only. And we try to point out to the court that there's also an issue of negligence. The court refused. So I think that is the major error that was prejudicial to the plaintiff in this case, especially in the face of a stipulation between the parties, the preparation of the case, no motion made, just coming in on the day of trial and saying this is the issue. Yes?
How would the situation differ if you had, not as a joint pretrial statement, but if you originally had a plaintiff's pretrial statement and a defense pretrial statement, and they came in on the day of trial and indicated that they believed that that was an issue of fact? Well,
we would have had their defense pretrial statement months in advance. We would have known what the issue was because the court said the parties have to meet a confer. How would the difference be? I might have prepared my expert differently or hired a different expert on the premises liability issue, or I would say, fine, they want to to argue premises liability, I'm going to argue negligence. Both issues are going to go to the jury. As long as I win on one of those issues, it doesn't matter.
So are you indicating that it was also a preparation for trial that it affected you as to the issue that they were proposing?
It was a discovery, experts, preparation for trial. We all had this joint pretrial statement. For example, the pretrial statement had a list.
You weren't exclusively asking the trial court to try this on active negligence. You had also in there premises liability as well, right?
No.
Yeah, both.
Plaintiff, but by the time of the joint pretrial statement, plaintiff and defendant both agreed only negligence, not premises liability. We both agreed.
Okay, go ahead, I'm sorry.
How long was the pretrial statement prior to the trial?
The pretrial statement, which was the result of conferences between the parties, was signed in March of 2010. The trial was in April of 2010. And the pretrial statement, I should point out, in the exhibits has a list of witnesses and a list of exhibits. We could not add a witness or a document at trial absent a court order. And here they're changing the whole game on the eve of trial without a court order, which is even more egregious. So we feel that the trial...
Are you saying then that you pretrial abandoned the premises liability for active negligence?
Yes, we did. We did. And they didn't complain. And they never challenged our negligence, active negligence cause of action. They never moved to strike it. They never made a demur. They never did summary judgment.
If we look in the record, we will find some sort of dismissal of that count or statement to the trial judge, we're abandoning our count on premises liability, we're only going on active negligence.
Yes, in fact, I made that statement to the court, and Disney's attorney said, you do that and your whole case is going to get thrown out because this is only a premises liability case. And in view of the comments by the court prior to that time, I was concerned that if I abandoned that my case would have been thrown out. So I said, fine, leave it in, but also give me negligence. I have two causes of action remaining. Let's give jury instructions on both causes of action.
Then getting back to Judge Rexedler's question, you really weren't caught by surprise altogether because you had the premises liability in there from the beginning, right?
But I didn't. We had premises liability in the beginning, but to achieve a premises liability case, you have to show a dangerous condition, which means other incidents, things of that nature, and there was difficulty getting substantial similarity in terms of other incidents, and in terms of the pretrial rulings from the court, we appreciated the fact that we were going to have a difficult time. That's why we made the election with the concurrence of Disney that we're only going to go on negligence, not premises liability.
But up until March 8th, a month before the trial, you had done the discovery then as to the premises liability because that was an issue up until March 8th?
Well, March 8th was the date that this document, this joint pretrial statement was signed. We had weeks before gone through, met and conferred, and decided what the issues were going to be. But I think for the nature of the questions that were asked in terms of the discovery, the depositions of the witnesses and the experts, our focus was on the negligence that he was misled into going on the ride. And basically, the vast majority of time spent preparing this case at a trial dealt with the issue of medical causation, the biomechanics. The issue of negligence, that was put to the side. The whole trial was on whether or not this ride could have caused those injuries. That was the focus of attention also during the discovery. That was the major issue in the case. Nobody was really questioning the fact that we could have a negligence cause of action. Never came up. Nobody ever suggested this is only a premises case.
When was this brought up to the trial court?
In terms of, well, when Disney came in with their amendment, their unilateral amendment, it was before plaintiff testified and also at the time of the jury instructions, because they could say all they want about dangerous condition, but if the jury instructions that I submitted, which were on negligence, were the ones going to the jury, the words dangerous condition would never appear in there. So never would have been any issue. So the issue really reached a head at the time we presented jury instructions to the court, and the court refused to give our instruction on negligence and only gave Disney instruction on dangerous condition.
How could you establish causation when there was nothing, the jury apparently found there was no dangerous condition concerning the ride. So how were you supposed to establish causation simply by saying, well, the sign, the warning on the sign just wasn't adequate. What caused the damages?
Okay,
And so how do you get around that?
But for the misleading of Mr. Cohn by the gentleman who had the last clear chance to tell him this is a thrill ride, but for that, he never would have been on the ride and never would have been...
Misleading him about what, sir?
Misleading him about the nature of the attraction. When an elderly...
But if you assume, because the jury found that there was no dangerous condition, what duty is there to warn about that?
You don't need a dangerous condition. For example, in the Etheridge case, there was a stipulation that the drainage was not defective or unsafe. But nonetheless, they found active negligence on the part of Disney in channeling people going over there and causing an injury. It was dangerous for Mr. Cohn. His body, under the conditions that he was in at the time, was not able to...
How can you say that his injury was caused by, the inadequate warning when there was the jury apparently found there was nothing dangerous about the ride to begin with? I mean, it seems to me like you're fighting an uphill battle just to get through the causation issue.
First of all, there was never a definition of dangerous condition existing, okay? So the words dangerous condition doesn't mean it's safe for everybody. It just means there's not a dangerous condition. That doesn't mean everybody 100% going on the ride can tolerate it. Otherwise, there wouldn't be need for having, medical warnings on there. So the fact that the jury found no dangerous condition does not mean that it's...
But Disney can't. Disney can't be held to strict liability in this case. I mean, they have to act as a reasonably prudent person would act under similar circumstances. And they gave the warning, and the jury apparently found there was nothing dangerous with the ride. You're saying that, well, he was a unique case, and he got on the ride and he was injured. What you're actually saying then is this is a case of strict liability, aren't you?
No, I'm not. I'm saying this is a case of negligence in the sense that he asked and wanted accurate information as to what this ride was about. They negligently misled him. That's the negligence.
Well, did they mislead him, or did they not answer his question?
Well, I think they're one of the same in this case, Your Honor. The fact
they didn't answer his question, right?
They didn't answer.
You'll see is not an answer to the question.
That is true. That is true. But when an elderly gentleman asks, he would have an expectation when he has two little kids next to him that he'd get a direct answer.
But he walked by the warning sign, right? And then he asked for some clarification, which the employee essentially refused to give him. Does that give rise to the kind of duty that you're describing here, where a park owner is actually misleading somebody?
I believe that their operations manual, operations guideline says, do not attempt to scare or underplay the nature of the Twilight Zone.
Is that the source of the duty? Is the manual the source of the duty? Does that create a duty?
The manual is part of what Disney considers to be reasonable conduct.
But it's not. It doesn't create a duty. I mean, if the manual says something that doesn't define the duty, that doesn't define the parameters of the duty.
The duty is what a reasonable theme park operator should do under the same or similar circumstances. And when you have elderly people with small children asking you about a thrill ride, and the word thrill ride doesn't appear anywhere on their signage.
Or are you saying that the employee had a duty to answer the question?
Yes.
And if he had reiterated precisely what the sign said, would you still have a claim for active negligence?
Well, if he said this is a quick drop into the Twilight Zone,
well, I mean, if he read him the sign,
then Mr. Cohn would have followed up and said, "What do you mean by that?"
Mm-hmm. Well, if he had said, "I'm not," that's the sign is self-explanatory. That's the best answer I'm going to give you.
Then he might have just gone out what's called the chicken door and take his grandkids and said, "This is not for me."
Mm-hmm. But would that have given rise to a cause of action? The employee
wouldn't have been on the ride. He wouldn't have been on the ride, so there'd be no basis. He wouldn't have been injured. He wouldn't have been put in a position which dynamically for him.
The employee had said, "You read the sign. That's all I'm going to tell you," and that was the only answer the employee gave. Would that be a breach of some duty that the employee had? Does the employee have a duty to affirmatively answer the question? I think
that the employee does not have an affirmative duty to unilaterally tell people something. They have an affirmative duty when somebody asks to respond.
Now, he couldn't have said, ignore the sign, don't worry about that, that's just overkill, it's no big deal, you'll be fine on it. Now that may be a problem, but when he just says, you'll find out, is that really the kind of active negligence that would allow a jury question?
Well, you have to couple that with the fact that the entranceway signage above there said service elevator, which in Mr. Cohen's experience, as he testified at trial, is a slow-moving elevator. So the fact that the employee did not give him a true and accurate description of what the ride was, plus service elevator, led him to believe this was a slow-moving elevator with some thrills in terms of excitement and something that he doesn't have to be physically concerned about.
Your time is exhausted, but I'll give you a couple minutes on rebuttal if you want. And
Thank you.
then you will have, instead of 20 minutes, 22 minutes. Okay? That will equal it out.
Good morning. May it please the Court, Wendy Loomish and Josh Moore from Carlton Fields on behalf of Disney. The issue in this case is whether or not the Court abused its discretion in rejecting plaintiff's general negligence instruction where plaintiff failed to plead, prove, or offer an instruction on active negligence independent of the claim that already was going to the jury on premises liability. And I think we have to focus on what the jury instruction was that was requested. It was general negligence. It wasn't what we're hearing about now.
Now, you acknowledged, though, that if they had pled in their complaint that the employee advised him to ignore the warning sign, in other words, gave him contradictory advice, that they would have a claim that would be a distinct claim from a premises liability claim.
Well, I think the problem there is you have to start back with the issue of the dangerous condition. And all of the claims in this case relate to that dangerous condition.
No, but I mean, even irrespective of whether it is a dangerous condition, if an employee actively misleads an invitee regarding the nature of the ride, that would give rise to a separate claim for negligence, wouldn't it?
Well, I think if they could demonstrate that that created a dangerous condition or that that was some kind of independent negligence, but that's not what we have in this case. And I think it's also important, the plaintiff suggested that they didn't know this was going to be a premises liability case. That's not the case they put on. You need only look at their brief to see how much evidence they attempted to put on the dangerous condition. They called our witnesses in their case, and they were attempting to prove the dangerous condition. The court looked at the issue at the charge conference, and I would point out that the first time that the plaintiff made any challenge whatsoever relating to this pretrial stipulation was at page 1608 of the transcript, when the plaintiff's case was almost closed and the court's starting to talk about jury instructions, and then they say, there was this stipulation. Of course, we all understand that premises liability is an aspect of negligence. So when we're talking about a negligence case, we're always in the concept of negligence. Premises liability is one aspect of that.
You indicated as far as 1608 in the transcript, did you file proposed jury instructions indicating a premise liability jury instruction?
Yes. Our jury instruction was the one that the court used, and it was an instruction on premises liability only.
When was that filed? Was that filed at the time of the trial, or was that filed prior to the trial?
I believe that it was filed prior to the trial, and let me see if I can find that reference. I'm sure it's referenced within our brief for when we filed those, but we absolutely filed instructions, and they were on premises.
Otherwise, you believe it may be referenced in the brief.
Yes.
Let me ask you another question, because you were referencing the fact that they knew about a premises liability claim and that they were putting on testimony. Were there any expert opinions that they had, or had experts that they had give opinions that they had retained regarding the dangerous condition at trial or prior to trial and deposition?
Yes, they put on their case with their witnesses about the existence of a dangerous condition. They used They used a number of our witnesses, they called them at trial, they presented their case that way, they put on a biomechanic, they put on their own testimony to support what they believed was the dangerous condition. And again, you read all about it in their brief.
Was there an opinion, though, that was asked as to, do you believe, in your opinion, that this is or is not a dangerous condition in the plaintiff's case in chief?
They certainly used our witnesses to attempt to put on that case, which of course the jury rejected. The witnesses that they were using from Disney were not agreeing that there was a dangerous condition. They also put on their biomechanic who talked about the forces and that the danger they believed in that condition. And again, look at their brief. The whole brief, which we were forced to respond to, even though it was somewhat besides the point, was their case about the forces involved in this incident. The bottom line on this is, if there was no dangerous condition, which is what the jury found, then the warning issue, there was nothing to warn about. As Judge Soraya talked about the warning language itself, it said it's a high-speed drop. There's nothing else there in this case. And I think most important is, it's their obligation as the proponent of the jury instruction and also as the appellant here to tell the court what that instruction would have been. And we know, based on general law relating to premises liability and negligence, it can't just be a general duty in the abstract, a general negligence duty. They didn't even specify duty to warn. They didn't talk about the employee in terms of the language. It was just a straight, was there a duty? We know that the duty in this case was to keep the premises reasonably safe and to give notice of any danger. They both tie to that. So to go back, if the issue is there's something active and independent, they had to come to the court with that instruction, and they did not do that.
You had indicated, though, that there wasn't any duty that was indicated or duty to warn prior to trial by them, but the pretrial statement that was originally filed, doesn't it indicate was there any negligence in its operation and or warning on the part of Walt Disney World for the Tower of Terror? Isn't there a reference there?
Oh, there is. To be clear, there's a warnings issue if there's part of the duty is a duty to keep the premises safe and a duty to warn of dangerous conditions. But the underlying point there is there has to be a dangerous condition about which you warn. And so the original pretrial statement talked in the broader language of negligence. When it got to trial, the issue was this premises liability. And what the court said when the issue came up was, I've got to instruct on what the correct law is. The court heard all of the evidence and considered it and concluded, apparently, that the only issue was whether or not there was a duty to keep the premises in a safe condition or to warn of the dangerous condition. So the court instructed on both of those theories. Clearly that was the instruction that was read at page 2757. And then if the jury found a dangerous condition, then they would go beyond that to look at the issue of whether or not there was negligence in failing to warn.
What about the theory of active negligence with the individual not informing Mr. Cohen of what occurred and having an alternate theory where they would have instructions as to both?
Right. The issue there is, in order for there to be an active negligence claim, they had to demonstrate some negligence that was independent and different than the negligence relating, or the premises liability claim relating to the dangerous condition. And the only thing that we've heard is they should have warned essentially about the dangerous condition. And more importantly, they didn't request that instruction. The only thing they asked the judge to do was to give a negligence instruction, which clearly would have been an error for the court to give. So had they wanted something different, and again, assuming they could support it, which we don't believe they could, they needed to ask for that. But the cases on active negligence, when you look at them, it's something that is different than the dangerous condition. And as some of the earlier comments reflected, I think it's very clear that here the issue was there a dangerous condition? Once the jury found no, then they couldn't get beyond that. There was no causation linking any of these other issues that the plaintiff had sought. And so we would ask that the court affirm. We believe that there was no abuse of discretion in the failure to give the instruction that the plaintiff requested, because that was an incorrect statement under the facts and under the law. Thank you very much.
Okay, thank you. Okay, I said I would give you a couple of extra minutes. She left about 11 minutes, so let me go ahead and reset this. And let me ask you this question. In reading your count 2 for negligence, it says essentially that Disney negligently, wantonly, recklessly, tortiously, wrongfully, etc., and then designed, processed, constructed, manufactured, assembled, prepared, selected materials and parts, represented to test and inspect, managed, maintained, repaired, serviced, sold, advertised, distributed, and so on and so forth, the Tower of Terror attraction and its component parts. And then you talk about negligently instructed others regarding the Tower of Terror attraction, failed to warn and educate and train its users, and fail to provide adequate restraint systems, and so on and so forth. That reads an awful lot to me like a premises liability.
And that is why, those are the 3 of the 5 elements of negligence that deal with design. We took those out in the stipulation. We said operation or warning. We didn't say design, operation, or warning. And number 5 in that
did you amend your pleadings to regarding count 2? Because count 2 reads to me, it seems to me it's so close to a premises liability cause of action. Did you amend your pleadings and tell the judge we're amending our pleadings? Or
no, but count 2 includes paragraph 5. Paragraph 5 talks about misleading Mr. Cohn. Paragraph 5 deals with the act of negligence at the ride.
But you pled and you alleged in your complaint it was the design, construction, manufacture, et cetera, et cetera, et cetera, and then you threw in the warnings and that sort of thing. It just reads like almost a textbook pleading for premises liability, and then you come up with the stipulation, well, we're gonna put in active negligence. I mean, I can understand why the trial judge, reading the pleadings and looking at everything, said, well, this is premises liability, and that's what we're going to go on, because it seems like you basically pled premises liability in both counts of your complaint.
Well, the last 2 paragraphs, paragraph number 4, number 5, deal with warning.
Right.
And the agreement of the parties dealt with not just general negligence. Was there any negligence in its operation and or warning? And the focus was similar to the situation in the Etheridge case, where you're dealing with, when you're dealing with active negligence, the negligent mode of operation theory relied upon by the plaintiffs is based upon an act of negligence on the part of a premises owner in the way the owner keeps its premises or conducts its business, and how that mode of operation affects his customers. And the case indicates you don't look at whether or not there's a dangerous condition, you look at the conduct of the defendant.
Right.
That's what we were focusing on in this case, was the conduct of the defendant in its operations, which would include how the cast member at the end conducted himself, and the warning, not only with respect to the verbal warning that he should have given Mr. Cohn when he asked, but also the signage. That was the focus. And the jury instructions...
Wrap it up, because you've gone way over your time, and
I'm sorry.
I need to make sure that it's fair to them, that you don't...
Just one point. The jury instructions, I believe, did not come in before trial, but during trial. The record, I think, should reflect that.
Okay, thank you very much. We'll argue it on both sides. All right.